Honor, I will now request the Honorable DCJ to continue the questions.
My Lord, please tell us what you understand by the term organizational leadership. Give us 4 strategic goals you would use to achieve organizational leadership and how you would implement the same.
I believe there are different styles of leadership and leading an organization. But the one I espouse most is leadership by objectives. Establishing a strategy, selling your strategy to the people, developing it into short-term, medium-term, and long-term work plans, developing smart objectives and deliverables, selling those, and then delegating generally to your teams to develop the work plans, providing also for the how those plans and objectives would be funded, and what capacity of personnel you need to implement your strategy in the short term, in the medium term, in the long term. That is the way I believe in dealing with leadership.
My Lord would not work alone and would not expect to succeed working alone. What teams would my Lord put together to assist in the optimum discharge of the judicial function and of the administrative function as Chief Justice?
First and foremost, I believe we need capacity in the office of the Chief Justice, first of all, because I've looked at the organogram, which is the strategic plan, and I've been wondering why there is nobody who works with the Chief Justice. I was told that the Chief Justice comes with his people and they are on short-term contracts and they come and go with the Chief Justice. My proposal, and having worked in the East Africa community with the Secretary General, is first of all to have a few key officials in the office of the Chief Justice to enable him to enable myself with my strategy. First of all, as the leader of the third arm of government, it is very, very important where we are to be able to unlock the matters which hinder us today. And I'm proposing, first of all, that I would, if it's possible, to have a principal liaison officer on a permanent basis in the office of the Chief Justice. They will be serving under the Chief of Staff to unlock the diplomatic initiatives in that office, the consensus initiatives. I would also want to work with a principal resource mobilization officer to assist me in unlocking the financial crisis which we find ourselves, which hampers our programs. So, and with that, I would also want to have a principal legal officer, a tripartite working in that office on a permanent basis, really, in addition to the other hand hoc officers. That was my experience with the East Africa community, and that's why they are funded 50% by the partner states. And we have to fund that organization through development partners, through that office, sitting in the office of the Secretary General to mobilize funds. And I think that, to me, that model would work very well for me. The key team in the judiciary also is the judges themselves, the magistrates themselves. You cannot achieve anything in the judiciary without them. They are my colleagues, my peers. I'll be only first among equals. One of my first initiatives will be, having looked at the report, the staff satisfaction survey 2018. I've also looked at the court users satisfaction survey 2019. I've identified areas of dissatisfaction which I would want to address as a matter of urgency.
Yes, my Lord, in fact, thank you for flowing into that area, because that's my second area of concern. So what have you identified from there? What is first the purpose of those employee satisfaction surveys? And what are you bringing in here, my Lord, as CJ, to right the situation from where it is?
First of all, I must appreciate that the satisfaction levels of staff and the court users are very high, contrary to the general perception out there. Actually, I was surprised looking at the percentages in every area. It looks like in almost 99% of the areas, the levels of satisfaction are so high. And that is why sometimes you wonder why the general perception out there appears so bad when a scientific survey shows a very high level of satisfaction. However, I identified key areas. With the court users, the matter is the time which it takes from the filing of the case to its conclusion. That's the main issue, really. That is where there is dissatisfaction. And that is the core of every initiative that the Chief Justice should embark on to unlock the potential of the judiciary, unleash it, so that we can increase the capacity of the judiciary to deal with the backlog. 2 years, 3 years, 4 years is bad for some dispensation of justice. And so the initiatives which are in the strategic plan include and the key enabler, in my own view, is the master plan, the ICT master plan.
My Lord, there are two issues here. There is the employee satisfaction, then there is the customer.
I was coming back now to the staff.
Okay.
With regard to the staff, and especially the magistracy, and the judges also identified two key areas of dissatisfaction: the promotion procedure and career progression procedure. The levels of dissatisfaction with that, in my view, especially the promotion, appeared to be very low, and I believe I would want to engage that area and have a document developed in a transparent manner to be implemented to completely deal with the promotion and career progression of staff, judicial staff in the judiciary. The other area identified is the disciplinary dispute resolution procedure, which actually is not even an indicator in that survey. Such an important issue, it was left out completely. Yet, this is a cause of staff suing their employer, judicial officers suing their employer, judges suing their employer. because they are not, we don't have a framework of dispute resolution. We don't have a framework of sorting out dissatisfaction within the judiciary. We don't have the procedure of disciplining especially the magistrates and other judicial is not transparent, is not known. And if it is there, I must say it is not known. And that is the cause of so much dissatisfaction. I would want to address that as a matter of urgency.
My Lord, the magistracy include the Kadhi.
Yes, they do include the Kadhi.
There was some discussion pre-2010 constitution about the Kadhi's court. Please tell us what that was, and today tell us the structural scheme we have in the judiciary about the Kadhi's court, the challenges they face, and whether truly they are part of the judiciary.
I must admit that I'm not very vast in that area, but I will say this, that I know for sure that the process of recruitment of a Kadhi is not well streamlined in the judiciary. And there's dissatisfaction in that area, in the manner the chief Kadhi is appointed. There was also discussion on how far the special needs of the Muslim community, and especially those dealt with within the judicial system, will be catered for without violating their rights as a Muslim community in Kenya and in the world at large. I believe those are the concerns which Kenyans continue to engage in, so that Kadhis, who are equal partners, equal citizens, equal Kenyans, I mean the Muslim community, are treated equally, fairly, in the way, in every aspect.
My Lord, as Chief Justice, that would be your concern to settle, as would the Court Users Committee functions and their performance, because my Lord would, of course, be the chair, the National Council on the Administration of Justice. Please tell us what the impact of CUCs has been to date, and how their performance is to honestly be assessed.
I noted that also as an area of dissatisfaction in the survey, that especially awareness. There's a big issue of awareness by the people of Kenya as to the existence of CUC.
What are CUCs?
Well, I thought we are talking about the Court Users Committees.
That's right. I'm saying you explain to us what those CUCs are, and under your leadership as both Chief Justice and Chair, how you would make them perform. Of course, you would answer that question with telling us what they are doing right now and how we would be able to assess their performance in improving access to justice.
Thank you very much. As the Principal Judge of Employment and Labor Court, I started the Court Users Committee for that court. I was also able to start the Court Users Committee for the Labor Court, in Kisumu, not to activate it, because it was dormant when I went there. And so I have a very good understanding of how the judiciary should interact with its key stakeholders to resolve especially the areas of dissatisfaction. And that is usually the CUC's regular meetings with all the spectrum of stakeholders, to where they give feedback to the judiciary, and judiciary answers their concerns, and we work out sometimes training programs, and together we agree on ways of resolving the problematic areas, especially the interfaces between the judiciary and the court users, which are problematic, especially the access to the registry, the facilities they use, accessible to them in the judiciary, taking care of the needs of the people with disabilities, dealing with issues of rudeness, issues of bribery, if they arise, and corruption. And so the satisfaction by the Kenyans will improve by the day as we enhance the capacity of the CUCs to deal with emerging issues. And when we do, because I believe we have been doing it, but also we don't talk very much about what we are doing. And that is why I saw in the survey that a lot of stakeholders were unaware that they in fact do exist. We had, for example, the marches during the Mutunga time. We had we have open days as models of the engagement mooted out by CUC. In fact, Madam Commissioner, when I was at the ELRC, I started the first Inns of Court in Nairobi, which is still working today between the bar and the bench. And I had several engagements through the Inns of Court, which I started as a principal judge, and which has been taken up by the current leadership, and it continues.
All right. My Lord, please tell us, as Chief Justice, my Lord would wear very many hats, at the minimum 5. Which of those does my Lord consider to be the most important, if that's possible? And how does my Lord hope to better the judiciary by the importance of that role?
The Chief Justice is the embodiment of the leadership and the institution of the judiciary. He is the face of the judiciary to the Kenyans who gave that authority unto us. So the Chief Justice as the leader of the judiciary, and the way he handles his internal affairs and external interactions with key stakeholders is the most important function of the Chief Justice, because those interactions will determine the internal satisfaction with his teams and the external satisfaction with his out there, and to a large extent determine whether we are able to mobilize funds to achieve our objectives. We are able to get, for example, the issue of 41 judges unlocked. That role of the Chief Justice, the ability to build consensus as a leader and the embodiment of this institution, is key and paramount. And you need a person who can be able to do that in a most judicious manner and amiable, diplomatic manner, yet decisive and honorable.
My Lord has sat in the Employment and Labor Relations Court since 2012.
Yes, my Lord.
As my Lord developed a particular type of judicial philosophy from my Lord's tenure at the court? If the answer is yes, how does that impact on my Lord as Chief Justice, particularly on employer-employee relations?
Madam Commissioner, I would not say that I have developed a particular philosophy other than what has been and a philosophy in me in every place I have worked. To administer justice in a fair, equitable manner, to treat people with courtesy, humility, and to make judgments which reflect the values, principles, and purpose espoused in our Constitution. Indeed, Madam Commissioner, the endings of our Constitution guide us in the way we interpret our law, in the way we implement our laws. Those are commands which we must have in mind all the time. And so, I just espouse the constitutional dictates, the principles developed over the years by the nations and the ILO, which have been adopted in this country as guides of what we call decent work and gender and human rights infused employment. Those are dear to me, and their values which are neutral and not biased in any way.
All right, thank you, my Lord. Now, is there a disconnect between the law and society? In case your answer is yes, how does my Lord as Chief Justice and leading an able team of judges and magistrates intend to reconnect law and society?
In fact, this builds on from where we were with the interfaces between the judiciary and the court users, because the court users are the embodiment of the society out there. So that is going on and is going to be escalated, and the communication channels especially, how we communicate the good things we do, because there are so many good things we do as a judiciary since JTF and SJT, I believe. And under the guidance of these commissioners too, there are very good things which you do. How well we communicate this will be part of my communication strategy to the people of Kenya. There is the issue of education and training within and without. And there must be also interaction in those trainings. We should also have joint trainings with the people out there, stakeholders. I believe that there's room for that, for training as we engage. I believe there's room for social awareness training of our judges. Social awareness training focuses on the values and the principles and the culture of the people, which of necessity a judge must be aware of as they dispense justice. And it's in that understanding that our decisions will become better and serve the people of Kenya more and more. I believe in that dearly, and I would embrace it fully as a Chief Justice.
Thank you, my Lord. As one of the major roles of the Chief Justice, one of the 5 I mentioned earlier, is being President of the Supreme Court and being the jurisprudential head of the entire institution. My Lord is aware that there's a difference between criticism and critique. So would my Lord first critique the performance of the Supreme Court to date? It's 10 years old. And 2, how would my Lord, as President of the court, bring a difference in that court?
I am aware that the Chief Justice, you are also the President of the Supreme Court, and therefore the first among equals in that court. I'm also aware that I have very senior judges in that court, many of whom I have personal interactions with, because as I said, I am very easy with interactions, be they upwards or downwards. So I also have studied and I do use many of the judgments of the Supreme Court in my decisions. And I know, for example, I can identify some decisions which I think have not stood well in my own. The first one, which has given us a lot of problems at the E&LRC and in the magistracy, is the Law Society decision on Weber. That decision, my problem is with the effectiveness of the orders often discharged, issued by the Supreme Court. Not only in that case, in Mitubel case, and in Moro Ateto case, very good jurisprudence, but in my own view, that more needed to be done, especially in crafting effective orders. Because justice orders are not issued just for the sake of it. Justice is dispensed to sort out problems in society. And therefore, the other day, just before Justice Maraga left, we had concerted efforts for him to explain to us in the ELRC and within the magistrates the meaning of that decision, Supreme Court decision, because it has created a lot of confusion across the board in the handling of Weber matters.
Weber. Mm-hmm.
Yes, it's a problem. So those are the issues, and up to now, and that will be, I would want to give that attention as soon as I am Chief Justice.
It is that I am looking for the benefit of all of us.
Yes.
So what are you going, my Lord, to do as the jurisprudential head of the judiciary and of the court of the Supreme Court in particular? What are you going to do so that Weber does not happen again, if according to you Weber is not good jurisprudence, and Muruatetu does not happen again, if according to you Muruatetu is not good jurisprudence? What is the role of my Lord as President?
First of all, I'll clarify about Muruatetu. My concern is not the decision itself, but how far the Court of Appeal went in having resolved very well, dealt with the issue of mandatory the death. I mean, they say mandatory, that declaring death sentence and as not a mandatory sentence. It's how far I thought they should have gone so that to deal with minimum sentences which are as harmful to the people of Kenya, especially in matters sexual offenses, and also There's also the issue which I don't know how it was addressed as to the
so
place.
how would my lord address it as president of the court?
We are collegial as judges of the Supreme Court. We sit in caucuses. We meet in colloquiums and we purpose to engage in manners, in areas where we could improve the jurisprudence. And that's my approach, being a very democratic leader, a very collegial leader, would be to want to utilize the jurisdiction of the Supreme Court to revisit its own decisions. I know some of those matters will come again because we have decisions being made at the lower level, which will come back again, and so there will be opportunity to revisit some of those issues, coming again through the High Court to the Court of Appeal. So there's that opportunity. And when we get those opportunities, it will be my time to use my collegial engagements, in my view, very good qualities, which I have, to create consensus within the law. And I also like good dissent, because it is in those decisions where we develop our jurisprudence. So my ability, Madam Commissioner, in building consensus, which I will do with all those judges there, and they are all my friends without exception. In that, I have had workings with them, including you, Madam Chairman, in the JLAC. I've worked with you in morning meetings for a long time. I've worked with each one of those judges. I know them personally.
True.
And I am able to easily deal with them at that level.
Thank you, my lord. Finally, from this end, that court, once every 5 years, is likely to hear the presidential election petition. Do you know what the court may have done in the last 1 year to improve its preparedness in discussing that major petition that comes once every 5 years? Part one of the question. Part two, what would my lord say has been the success or lack of it in the manner the court has handled the last 3 presidential election petitions?
I know, as a matter of fact, that we have Supreme Court Rules 2020, I believe, which have been developed to better the procedures of the court. And since that is the main mandate of the court, I believe that will aid in handling of. We have the Supreme Court elections rules also, which I believe have been tackled in that process to improve the manner in which the court handles.
Any specific one, my lord?
Yes.
Any specific one?
Specific?
Any specific rule you are talking about, my lord?
I believe I have come across the Supreme Court Rules 2020, if I'm not wrong, in my readings, and which I suppose is an improvement on the previous rules of the court. And although I have not had an extensive interaction with the specific rules which have been developed, and you would understand why, being how busy we are at the level we serve. So we tend to engage with the Supreme Court matters when they directly affect the issues we are dealing with. But for the purposes of preparing for this interview, I believe I've interacted with new initiatives in that court, in development of regulations and rules, which I believe will help in the improving the capacity to handle future election petitions. Then coming to the issue of the petitions, I have interacted with 2013. Is it 2013? Rider 1. I've interacted with Rider 2. The 2017 ones, and my issue is that there is uncertainty in the law of resolving presidential elections arising from those two landmark decisions, the Mutunga one and the Maraga one. And the Supreme Court has got the mandate to depart from its own decisions, and so there's nothing wrong with areas of disparity because they are permissible in interpreting, especially in interpreting Section 83 of the Elections Act vis-a-vis the Constitution, and the meaning of the impact of transmission of votes from the polling stations to the tallying centers, the national sector, how that impacts the election and the final decision result. I think these areas of disparity in how the Supreme Court went about those issues in the Mutunga case and in the, I call it the Maraga case, Rider 1, Rider 2, and the values, the principles in the Constitution, how they were applied to the election process, the importance of the polling station as a primary area of universal suffrage, where the people speak, vis-a-vis irregularities which might occur along the way, how we, I believe those are the areas which of disparity in those decisions, and jurisprudence will develop as we move on in those areas, no doubt, Madam Commissioner.
Thank you, my Lord. Thank you, Chair.
Thank you, Honorable Acting